Hi, I'm Doug Weir from the Conflict and Environment Observatory, CEOBS. We're a UK charity that undertakes research and advocacy on the environmental dimensions of armed conflicts. For nearly a decade now, CEOBS and its predecessor have been lucky enough to work with a community of legal experts involved in work to clarify and strengthen the legal framework protecting the environment and all those who depend on it before, during and after armed conflicts. The main focus of our attention has been a set of legal principles that are being developed by the UN's International Law Commission as part of its PERAC study. PERAC stands for the Protection of the Environment in relation to armed conflicts. Now, conflict in the environment is a really broad topic, and there are currently 28 PERAC legal principles covering a wide range of issues. In this video, we'd like to introduce you to a few of them, those that are particularly important for environmental peace building. We asked leading experts to tell us about them, so you'll hear about the role of corporations and the extractives industry, about environmental protection in situations of occupation, about the intersection of human rights and environmental peace building, and about the role that conservation and biodiversity protection could also play in peace building. But before we get onto these topics, we'll hear a little bit about what environmental peace building is and the role these principles can play in it. We'll also hear about the International Law Commission's draft principles themselves and how they've been developed. We'll finish off with a look at how we can ensure that the PERAC principles have an impact on the ground. A huge thank you to Geneva Peace Week for giving us this platform, and to all of our contributors, in particular to Amb Dr Marja Lehto, the International Law Commission Special Rapporteur on PERAC, all of whom have braved the vagaries of modern technology to help us put this video together for you.
Bruch. I direct international programs at the Environmental Law Institute, and I'm president of the Environmental Peace Building Association. I'm going to talk about the importance of the ILC's draft principles to environmental peace building. Environmental peace building is the process of governing and managing natural resources and the environment to support durable peace. It includes efforts to prevent, mitigate, resolve, and recover from violent conflict. And it involves a wide range of resources, from renewable natural resources such as land, water, and forests, to non-renewable natural resources such as oil, gas, and minerals, as well as ecosystems and their services. Environmental peace building provides a framework for contextualizing and linking tools for managing environmental risks and opportunities across the conflict life cycle, as seen in this figure, from conflict prevention on the left to mediation in the center, and peace building, peacemaking, and post-conflict recovery on the right-hand side. It addresses both the risks and opportunities presented by the environment and natural resources to peace. On the risk side, these are highlighted in red across the top of the figure, environmental peace building understands that grievances over land, minerals, and other natural resources can escalate to violence, that natural resources can finance and fuel armed conflict, and that natural resources can be an incentive for peace spoilers. On the opportunity side, and these are represented by the black text under the curve, good environmental governance can be a means to prevent disputes from escalating to conflict. Shared interests in natural resources and the environment can be an entry point for dialogue and an incentive for peacemaking. And natural resources are essential to livelihoods and revenue generation, necessary to recover from conflict. Environmental peace building is a rapidly growing field of practice and research at the intersection of environment, conflict, and peace. The ILC's draft principles on protection of the environment provide the international legal foundation for environmental peace building. Historically, discussions of international law on the topic focused on international humanitarian law, which applied only during armed conflict, and these provisions generally focused on limiting efforts that targeted the environment. The draft principles extend the protections of international law in three important directions. First, the draft principles draw upon multiple bodies of international law. These include international humanitarian law, including the law of occupation, international human rights law, international environmental law, international criminal law, UN Charter, international trade law, and other bodies of international law. So it's much more rich, much more diverse set of protections than found only in international humanitarian law. Secondly, these other bodies of law extend the international legal framework temporally, so that the draft principles include protections across the conflict life cycle, before, during, and after conflict, as well as in situations of occupation. And third, drawing upon the other bodies of international law, the draft principles also offer protections in situations of non-international armed conflict, where international humanitarian law has historically been weaker. Just as environmental peacebuilding provides a framework for linking approaches for managing environmental risks and opportunities across the conflict life cycle, the draft principles link diverse protections from diverse bodies of international law, protecting the environment in relation to armed conflict. Now, environmental peacebuilding is still a new field, and as such, it's still evolving and maturing. The development and adoption of the draft principles are important to the further ongoing evolution and maturation of environmental peacebuilding. They provide a legal foundation for the field that brings together and codifies a diverse set of practices before, during, and after conflict. The draft principles collect in one place diverse environmental protections from these bodies of law, and as such, they reinforce a central premise of environmental peacebuilding, that environmental peacebuilding necessarily integrates a range of sectors, from security and peacebuilding, to environment, to development, to humanitarian assistance, and so on. I expect that as environmental peacebuilding continues to mature, that international law will also continue to develop and grow. The draft principles provide a firm foundation upon which to grow.
Regarding the scope, what I would like to say at the outset is that the draft principles deal with the protection of the environment in relation to armed conflicts. This means that the ILC work is not limited to situations of armed conflict as such, but tries to cover the whole conflict cycle. The draft principles address armed conflicts, situations of occupation, peace operations, and post-conflict situations, as well as preventive measures that should be taken even before a conflict breaks out. Another significant feature, which is closely related to this broad perspective, is that the topic draws from different areas of international law, in particular international environmental law and international human rights law, in addition to IHL, which obviously is lex specialis in armed conflicts. This means further that the topic does not only focus on the obligations of the warring parties, but also seeks to clarify what other states, non-belligerent states, or international organizations should do to enhance environmental protection in relation to conflicts. And in all this, I should add, the Commission has been able to build on and benefit from the numerous post-conflict environmental assessments that have been conducted in the past few decades, and of related research. You also asked about the normative nature of the principles. They are, of course, not binding as such. Quite a few draft principles nevertheless build on and reflect established obligations based on widely ratified treaties or international customary law, interpreted in an environmentally friendly way. Other draft principles are based on existing practice by states or international organizations. In that sense, I can say that the draft principles are intended to either clarify existing international law or to contribute to its further development. I believe that the ILC work has already contributed to sensitizing states to the environmental impact of conflicts and to the relevance of environmental obligations even in situations of occupation or armed conflict. A number of principles remind states of their existing obligations regarding the environment in armed conflicts and in conflict-affected areas. Some draft principles have been formulated to provide fairly concrete guidance to states and other actors, specifically asking states to take legislative or other measures to enhance the protection of the environment in relation to conflicts. They may, for instance, suggest the designation of protected zones or inclusion of environmental clauses to peace agreements or other agreements. They ask states to introduce environmental due diligence requirements for corporations and other business enterprises operating in conflict-affected areas, and to hold such entities liable for the harm that they cause. The draft principle on peace operations asks states to take measures to reduce the environmental footprint of such operations. These are a few examples. Where the draft principle has been cast in general terms, the commentaries expand on what it could mean in practice, highlighting opportunities for enhancing protection. And let me also add that many of the draft principles are based on what states already do, reflecting and encouraging an emerging practice.
My name is Richard Pearshouse and I'm Head of Crises and Environment at Amnesty International. I'm responsible for advocacy on these issues, but also for research. And as a researcher, one of the light bulb moments for me on this issue happened at the end of 2018 in northwest Iraq, where we were researching on the ground the effects of Islamic State's scorched earth tactics when it withdrew. This was about a year after the cessation of hostilities, and Islamic State, when they withdrew, essentially did as much as possible to destroy the rural environment of Iraq. We were in the to the north of Mount Sinjar, which is a predominantly Yazidi minority area, where the destruction was particularly brutal. And we were traveling in largely rural areas. We went out to one particular farm where we were very keen to sort of work out what had happened to this farm. The farm had been held by Islamic State, but on retreat, they had destroyed much of the infrastructure. The area was clear of landmines, we knew that much. And when we approached the farm, we saw a farm building which had been destroyed. We saw orchards where there had used to have been trees and they had been cut down. The fields were obviously barren. And we approached a water well, a shallow tube well, where the cover was back. And around the edge of the lip of the shallow tube well, we saw a brown, blackish, viscousy substance. That was oil. Now, in this part of Iraq, oil doesn't spurt up from the ground spontaneously. And the irrigation pipes that led off from the shallow tube well, where irrigation water had been drawn up, were themselves broken, and you could see where through the cracks oil had also been pouring. And that was the moment where it occurred to me that what we were witnessing there was evidence of a war crime. Because on retreat from this particular area, Islamic State did all they possibly could to leave the area uninhabitable for the civilian population that had been there beforehand. So they obviously destroyed buildings, they cut down trees, they spiked irrigation wells. And in this part of Iraq, the farming is largely subsistence farming, maybe a little bit more to sell to market, but it's dependent on water. It's an incredibly arid area. And so Islamic State understood perfectly well that by sabotaging an irrigation well, you would render that farm unfunctional for the civilians who used to work there beforehand. We talked to well engineers, the people who were responsible for fixing wells, And they told us that of the approximately 450 wells that had been functional before Islamic State occupied this particular part of Iraq, 400 had been put out of action by Islamic State by spiking by oil, by placing bullets or gravel down the actual pipe of the well, by severing the pipe, these sorts of things. And Islamic State knew exactly well now what they were doing with that. Now, under international humanitarian law, all parties to a combat should respect that principle of distinction between military objects and civilian objects. And by not doing so, Islamic State deliberately targeting a civilian object, they were committing a war crime. There's been a lot that's been understood about Islamic State's crimes in Iraq and in Syria. A lot more needs to be understood. And one of the things that needs to be better understood is the way in which they targeted the natural environment as a way of carrying out and furthering their attacks on civilian populations. So it's important for the historical record around war crimes in Iraq committed by Islamic State, but it's also important politically in terms of how Iraq rebuilds a year on, or now 2 or 3 years on from the cessation of hostilities. Because traveling through largely urban areas of Iraq, there was, even at this stage, reconstruction efforts. There were those reconstruction efforts that were taking place. In rural areas, there was almost nothing. The landscape looked almost identical as to that when Islamic State had withdrawn. So one of the points of the research was showing that discrepancy and reminding policymakers, both in the Iraqi government and the international community, not to forget the rural population and the rural landscape in terms of how they rebuild, in terms of where they put reconstruction funds. In terms of the ILC's draft principles, there are two that are relevant to this particular piece of research and advocacy in Iraq. One is the draft principle 14, which talks about that principle of distinction between civilian and military objectives. And the other is draft principle 24, which talks about the need after the conflict has finished to undertake assessments of the extent of environmental damage and to not just assess it, but actually to act on that in terms of environmental remediation, in terms of how you build back. In this case, it would be essentially helping Iraqi farmers to rebuild their irrigation wells. So I think the draft principles are an incredibly important set of principles that reminds the international community and those of us working in this space of the importance of protecting the environment during conflict and also how you build back after conflict. Because if there's one thing we know from conflict in places like Iraq, but many others, conflict is cyclical. So what happens after the war is also what happens before the war. And if we forget about the rural population and their livelihoods, then you have a large disaffected population without employment who are unstable and do not feel as though the government is looking out for them. So for those reasons, I believe that this is an important set of international principles. It's one where human rights are inserted in some of these principles. And we as organizations need to be doing more to further the broader agenda of respect for these international principles of existing international law, as well as on the ground undertaking further research to work out how the environment is impacted by conflict and how we better build back after conflict.
My name is Daniëlla Jong, and I'm an associate professor at the Grotius Center for International Legal Studies at Leiden University. And I've been asked to discuss the role of corporations in environmental peace building. Corporations, in my view, are essential partners in environmental peace building. This is also recognized in peace agreements as well as in environmental peace building strategies, but also by the Sustainable Development Goals, which actively promote public-private partnerships. This applies not only to corporations that operate in countries that are transitioning from armed conflict to peace, but also for corporations doing business with these countries, for example, through the purchase of minerals or timber, as well as to institutional investors, such as pension funds. I would therefore describe the role of corporations in relation to environmental peace building as one that is primarily supportive. Corporations can and do contribute greatly to environmental peace building. Nevertheless, we have also seen examples in the past decades of corporations that actively undermine environmental peace building. And a conspicuous example, and close to home for me, is the Oriental Timber Company that operated in Liberia under the presidency of Charles Taylor. And the owner of that company, Guus Kouwenhoven, has been convicted by the courts in the Netherlands for first undermining the UN arms embargo that was imposed against Liberia by supplying arms to Charles Taylor, and on the other hand for aiding and abetting with the commission of war crimes. So apart from these culprits, everything is well, and there's no need to address corporate responsibility. Is that what you're actually implying, you may ask? Well, no, that's not a conclusion that we can draw. And so in the majority of cases, the contribution of corporations in undermining environmental peace building is indirect. A particularly pervasive problem in this regard is the trade in so-called conflict resources, and so natural resources that are used to finance armed conflicts. And the illegal exploitation that underlies this trade in conflict resources is associated with serious human rights abuses, as well as with severe damage to the environment. This is an actual problem, yet corporations that do not always have to be aware of the fact that they are purchasing conflict resources. Supply chains have become so complex that the origin of the minerals that corporations purchase is not automatically known to them. So how do the ILC principles on the protection of the environment in relation to armed conflict contribute to addressing these problems, you may ask? Well, Principle 10 encourages states to take appropriate measures aimed at ensuring that corporations exercise due diligence, including, very importantly, measures aimed at ensuring that natural resources are purchased or obtained in an environmentally sustainable manner. So it is precisely through the process of due diligence that corporations can prevent contributing to human rights abuses as well as environmental harm in countries that are either in an active armed conflict or transitioning to peace. So it is therefore essential that states, and then I'm looking specifically at states in which corporations have their main seats, so the so-called home states, to follow up on this principle and to make sure to include corporate due diligence in their domestic legislation. In this way, they would not only help to address corporate responsibility, but also give effect to their own responsibility to protect or in any case, their responsibility to protect human rights under relevant human rights conventions. So Principle 11 of the ILC PERAC study complements Principle 10 in the sense that it encourages states to hold their corporations liable for harm caused by them to the environment in conflict and in post-conflict settings, including, very importantly, harm that is caused by subsidiaries acting under the de facto control of these corporations. This principle is essential for environmental peace building, as it gives expression to the complementary responsibility that home states have with respect to their corporations when they operate in situations that are characterized by institutional breakdown, which is typically the case in conflict situations, but also in post-conflict settings. So to conclude, in my view, the PERAC principles provide a solid basis for a new system in which responsibility for addressing corporate wrongdoings is equitably shared between, on the one hand, the states in which these corporations operate, so the states that are in the process of peace building, but on the other hand also the home states. And so the groundwork for such a system has been laid in recent years through other fora and instruments. So it is now up to the international community to further define and implement this system of shared responsibility. And the PERAC principles, in my view, have an important role to play in providing further impetus to these developments.
Occupations often create or facilitate environmental problems that have implications for peace building and the well-being of the occupied population. The 53-year Israeli occupation of the Palestinian territory represents a prolonged belligerent occupation, but it also represents an apartheid, annexation, and also colonization. And a central feature of this occupation is the permanent nature of the settlement construction, which is sustained by Israeli and international corporations. Much of the environmental damage in the West Bank is caused by corporations operating unconstrained in various industrial and agricultural settlements. Geshuri Industries, for example, is a chemical plant. It was prevented from operating in Israel under Israel's environmental law, but now has been green-lighted to operate in the industrial settlement of Tulkarem. So by relocating the factory and its emissions, Israel is violating the protected Palestinian population's right to health. And other environmental harms are evident from the pillage of non-renewable finite Palestinian quarry resources by German company Heidelberg Cement and the mass exploitation of Palestinian Dead Sea minerals for the manufacture of cosmetics by Ahava. And this is a company which is operated by Chinese parent company Fosun Group. And these actions highlight how the belligerent occupant works together with corporations, willfully violating its obligations to respect and protect the environment in the case of prolonged occupations. So while acknowledging that the occupying power must respect the laws enforced prior to the occupation, the new draft principles add emphasis to an extra layer of protection for the environment during military occupation. And this is that the occupying power shall respect and protect the environment of the occupied territory. So, for example, Draft Principle 20 places significant obligations on the occupying power to take appropriate measures to prevent significant harm to the environment of the occupied territory that is likely to prejudice the health and well-being of the population of the occupied territory. And here the draft principles recognise that harm to the environment may also have adverse consequences for the population of the occupied territory, in particular with respect to the enjoyment of certain human rights, such as the right to life, the right to health, and the right to food. And this is an important positioning of the protected population and the environment to the fore of the occupying power's considerations during its military administration of occupied territory during an international armed conflict. Principle 21 reflects an important development and a new shift in the discussion on the occupying power's administration and use of natural resources in occupied territory, from one of usufruct to the more contemporary concept of sustainable use. I think an important qualification here is that the use of natural resources refers to the use of public immovable property. The occupying power does not have an all-encompassing right to use privately held immovable property. And furthermore, the object and purpose underpinning the provisions is not a green light for the occupying power to accrue a war booty or to benefit themselves, but the actual protection of natural resources and infrastructure of the occupied territory, which if neglected would fall into disrepair. Again, this is always with the understanding that in a situation of occupation, this is temporary, and the occupier therefore does not have sovereign rights to permanently alienate the natural resources. So while we welcome the draft principles and the emphasis on sustainable development, and particular the obligations on the occupying power to take appropriate measures to protect the health and well-being of the occupied population, we also have to deal with the broader reality of the situation. And that is that along with the occupying power itself, that third states also have obligations to respect and ensure respect for international humanitarian law. And here we note that there are supply chains with the receipt of goods into third states of products which have been illegally pillaged from archaeological, agricultural, industrial, and touristic settlements in occupied territory, such as the occupied Palestinian territory. And this results in environmental harms which prejudice the health and well-being of the population of the occupied territory. And where we really see a value in the draft principles is the welcome responsibility on third states to hold corporations liable. For Palestine, this is of key importance. Many of the companies are also listed in the UN database of businesses active in the illegal settlements. And we emphasize that it is the responsibility on third states where the companies are domiciled in their jurisdiction to ensure that corporations are held liable for operating in settlements in contravention of international law where they are causing environmental and other harms. So could principles like these contribute to environmental peace building in areas like Palestine? And I think here it is important to remember the power dynamic of military occupation, where the occupying power has effective control over a subjugated population who are then governed under military rule. So the protected civilian population are already in a position where the military, under military orders, may have appropriated their lands, destroyed their properties, established entire areas as closed military zones, and conducted hostilities in a manner which have caused environmental harms, or they might have illegally settled in corporations and third actors into the occupied territory, who then in turn cause industrial and environmental harms. So it is usually difficult to ensure cooperation in any real way between the occupying power and the protected population, as the relationship is already one of military dominance, and the environmental harms are the result of other illegal acts being perpetrated by the military forces in occupied territory. And this is especially true of the type of prolonged occupations that we see in contemporary hostilities, such as in Palestine. So we need a strong understanding that for environmental peace building and the realization of the occupied population's right of self-determination and permanent sovereignty over their lands and natural resources, that we need to operate under the premise of consent of the occupied population for the development of their natural resources, and where this is breached, to ensure responsibility of states, including third state responsibility, which is highlighted and triggered. So it is important then to emphasize even more the responsibility of third states and their role in environmental peace building by ensuring the rule of law and also providing avenues for justice and accountability. And here, for example, we see progress with the draft principles 10 and 11 and the responsibility of third states to hold corporations domiciled in their jurisdictions liable for environmental harms. Thank you.
So with a lot of my research or the work that I've done in Central America and East Africa, I've been looking really specifically at transboundary protected areas or kind of national parks or conservation areas that straddle international borders between countries, and looking at how the countries work together, as well as how the communities participate in the transboundary conservation or in conservation initiatives around those transboundary areas. And it's been interesting to look at how these places can contribute to conflict resolution in different ways. Does it contribute to the international conflicts between the countries? Does it contribute towards social conflicts between different peoples, including between the communities and the protected areas? And does it contribute towards something that I like to think of in terms of sort of a ecological piece, you know, the human relationship with the rest of nature, the non-human aspects or other species, and then looking at peace building actually in terms of all three of those dimensions. And in that way, I think that actually biodiversity conservation has a lot more to offer than just forming habits of cooperation between people or between states. You know, you're talking about places where in some cases it becomes, you know, there's a lot of historical reconciliation that has to happen. Maybe the protected area came through or was established through a history of violence, displacement, people moved off of their land, access and rights to resources that were denied. And so there's actually a long history of conflict that exists or violence that exists that there's a peace building opportunity for that goes beyond the interstate relations. And that actually is an important aspect, I think, of what area-based conservation can offer to environmental peace building. It's an opportunity for the social relations between people and conservation itself to be restored or healed. And it's also an opportunity for people and nature to reconsider their relationship. In a lot of area-based conservation initiatives, we're looking at hard borders between the people and nature itself, or people and the environment. And that's a bit different than when we think about sort of conviviality or human existence or cohabitation with species in non-area-based conservation areas or initiatives. So sometimes if you have that hard line between people and nature, then you have an actual peace building opportunity between the humans and the environmental space itself, if that makes sense. So if we think about the potential risks or dangers of these kinds of conservation initiatives or even area-based conservation, then that's I think an interesting aspect to think about. You know, there is, as I've mentioned, a lot of actually violence attributable to the conservation activity itself. The establishment of an area that's distinct from a human settled area, you know, a separation of humans and nature as park versus people, or park versus kind of human inhabited land or human usable land. And that's an opportunity for, again, as I was saying, that social reconciliation between the people who establish a zone that's off limits to others, or between the people and their own relationship to the resources or the wildlife or the nature that exists inside of it. And when you think about this kind of activity in a conflict zone, in places where you actually have armed conflict, and you start to trace sometimes the lineage of that conflict itself. In the greater Virunga landscape, where I've done some of my research on the borders between the Democratic Republic of the Congo, Uganda, Rwanda, or even on the border between Uganda and South Sudan in the Kidepo Valley region, you're looking at armed groups that have a connection sometimes to a history of forced displacement because of the conservation initiative itself. And so now the armed conflict actually also has a connection to a conservation-induced violence. And so the conservation initiative now has maybe a responsibility to peace building in a different way. That's being, you know, it's more than just, do we work together as two states across a border to manage a natural protected area? Maybe there's a social peace building element and responsibility to actually restore some of that historical, you know, rebuild somehow the historical, what would I call that? Maybe it's a restitution for the historical violences that have taken place. Let me think what else. And I think also this is a time when biodiversity conservation, as well as environmental peace building as kind of separate movements or activities, are being forced to think about their own approaches to you know, their means to their objectives. In some cases, the environmental peace building approach has also been seen as too top-down, too externally imposed, and conservation, and especially area-based conservation initiatives, have been seen as very much in the same light, coming from international NGOs funded by external donors, outside agendas that have very, very kind of long-standing implications for people who are displaced from livelihoods or access to resources. And so it's a time actually for all of us to be thinking about how are we going about not just environmental peace building, but biodiversity conservation as a means to environmental peace building. A lot of the literature that we're seeing now around coercive practices, green militarization, it's the same thing. You know, when we look to the security forces to bring peace in places of protected areas that deal with or face armed occupation. We need to think about that quite critically. And actually, that's one of the areas where the draft principles by the International Law Commission are interesting. They talk about enhanced protection for protected zones, and transboundary protected areas actually are the perfect fit as a protected zone. It says that they internationally designated areas qualify as protected zones that receive or benefit from enhanced protection during armed conflict. So when we think about it that way, then transboundary protected areas should be special places of peace in a way during times of armed conflict between countries. But one of the challenges has been that these can often become the places of conflict, and so then you have militarized forces in the conservation area, trying to either neutralize a conflict situation or neutralize armed groups, and that actually goes against or could undermine the protection of the draft principles. They say that once these areas become militarized, or that a military presence exists inside of the protected zone, then the protected zone status actually falls away. So that actually calls on all of us to think about an alternative approach to dealing with armed conflict and its impacts on protected areas, including transboundary protected areas. It means that we need to look at non-violent ways, non-militarized ways of addressing armed conflict in conservation areas. And I think that, again, this is speaking to the call that, conservation in general and environmental peace building are facing in terms of, looking at alternative approaches to doing the so-called business as it has been. Yeah.
Hello, my name is Stavros Pantazopoulos, and I am the Legal and Policy Analyst of the Conflict and Environment Observatory. The previous speakers have highlighted different aspects of the United Nations International Law Commission's principles on the protection of the environment in relation to armed conflicts and their relevance to environmental peace building. In this talk, I would like to focus on the implementation of these draft principles, which are expected to take their final form in 2021 or 2022. It is important to note that the PERAC principles are not a binding international legal instrument. Instead, they are a mixture of binding obligations, best practice, and non-binding recommendations, which together are helping to progressively develop international law in this field. To begin with, I will briefly touch upon the various obstacles that present themselves when a state or another addressee of the ILC principles attempts to implement PERAC norms, and especially the International Law Commission's principles. The first obstacle is to clarify which obligations apply to states and to other actors, such as non-state armed groups or international organizations. The Commission has done a great deal of work to help with this. Another obstacle is the infamous lack of accountability, a recurring phenomenon when it comes to violations of the laws of war. So, how could states and relevant international actors be encouraged to comply with these norms? Or in other words, what is the role of the international community and civil society in this regard? Part of the solution is to convince states and other relevant actors to make clear their commitment to protecting the environment in relation to armed conflicts in general and to relevant obligations in particular. Many initiatives of the international community have emerged in the last decade, offering such a chance. In my opinion, the most prominent of these initiatives is the International Law Commission's draft principles. As previous speakers have also highlighted, they are great potential in many respects. But this is merely a partial solution. Civil society organizations have a huge role to play in ensuring that PERAC norms and especially the ILC's principles will be upheld. It is our responsibility to advocate for their implementation and demonstrate their untapped potential to states and other actors. For example, it has by now become common knowledge that matters relating to the restoration and the protection of the environment damaged by the armed conflict should be part of peace processes, including in peace agreements, as ILC PERAC Principle 23 stipulates. To this end, the international community writ large and civil society should make sure that this is the case. Another example of the role that civil society could maintain in strengthening PERAC and by extension the implementation of the ILC principles is to trigger the jurisdiction of, or at least bring these issues to the attention of, courts and tribunals, either international, such as the International Criminal Court, or even domestic, national ones. The underlying rationale is to raise the profile of wartime environmental damage and thus to raise awareness of the issues at hand. It is equally important to highlight the instances where relevant actors have actually complied with their international obligations pertaining to environmental protection in armed conflicts. This is the idea of foregrounding a positive narrative of implementation instead of focusing exclusively on violations of the normative framework. Having said that, we should bear in mind that states remain the primary international lawmakers and enforcers. In essence, civil society and the international community have their own separate role in stimulating the interest of states in PERAC, but states remain the key actors in this domain. I would like to close this talk by making specific reference to civil wars, or as the technical term is, non-international armed conflicts. It is a truism that the applicable law in this type of conflict is much more underdeveloped as opposed to the law of international armed conflict, that is interstate wars. And this is again a byproduct of the current system of international affairs, where states remain the key players, but at the same time they're unwilling to grant political legitimacy of any kind to non-state armed groups. The ILC principles have made a huge step to the right direction by espousing a holistic approach, thus covering both international and non-international armed conflicts. Nevertheless, the challenge remains how to convince non-state armed groups to comply with the principles. And this is where the international community and civil society have a significant role to play by helping non-state armed groups become familiar with the principles and, more importantly, with the benefits of implementing them, both to their objectives and to environmental protection as such. To conclude, the international community and civil society can facilitate the implementation of the ILC's principles through a web of initiatives and efforts, which involve advocacy, cooperation with relevant actors, including non-state armed groups, and by raising awareness of wartime environmental protection, either by resorting to judicial institutions or by promoting a positive narrative, where, of course, this corresponds to actual practice on the ground. Thank you very much for your time.